Hello, Dr. Bechtel here. Hope everyone is well. This is a lecture about spousal support, also known as alimony. And getting started. All right. The term alimony is described as spousal support, and it's a general term for court-ordered transfer payments from one spouse or former spouse to the other. In Florida, it's called maintenance when it's ordered during a marriage without the existence of a divorce proceeding. For example, temporary alimony and separation would fall under the category of maintenance. When it's ordered at any other time, it's called alimony. The history of alimony is important to this lecture. Married women once had no property rights, and until the Married Women's Property Act in the late 1800s, upon a divorce they had no means of support. The wife could receive continued support in the form of alimony if she was the innocent spouse, and it served as a punishment to the husband for his wrongdoing, such as adultery or abandonment and other things. Being a drunkard. The rights of women to control their own earnings, to sue and be sued, and own property. When women got these rights, it ended some of their dependency upon alimony. So all forms of alimony in Florida are fundamentally driven by a disparity in the financial resources of the parties, specifically the claiming party's need and the other party's ability to pay. And that's per Florida statute, chapter 61.08, subsection 2. The additional requirements needed to support a claim are minimal when the parties are still married. There are technically two overall categories, the maintenance and alimony again, but in Florida, maintenance states, per the previous definition, support during marriage, anytime before the divorce becomes final. Alimony, though, is for post-dissolution, being after the divorce, and includes some short-term post-dissolution, such as bridge the gap alimony, or long-term alimony, such as durational and lump sum alimony for special circumstances. The purpose, when you're working with alimony, analyzing the situation for a client, look first to the purpose. What need does the alimony type fill? So what need needs to be filled? Are there living expenses of the client that cannot be met without the support? Is there a rehabilitation needed, such as education? And is the transition to single life creating potential hardships and other matters that come along? The duration of the marriage is a guiding principle in Florida statutes for some types of alimony, and it's based on the length of the marriage. So it limits the discretion of the court. So a short-term marriage in Florida is of a duration less than 7 years. A moderate-term marriage is of a duration greater than 7 years, but less than 17. A long-term marriage is a marriage of a duration of 17 years or greater, and that is governed by Florida Statute 61, Chapter 61.08, subsection 4. Modification is also a principle to look at when you're analyzing the aspects of alimony and how it fits into a client's situation. And there are certain specifics that we follow about modification and alimony awards. So the type of alimony does make a difference in terms of modification. And the termination is another important factor. And how long should the obligation last? When should it end? I want to mention that these are, I'm just going to call these adulting types of quandaries. Well, I mean, not quandaries, questions you would ask. The person who has more life experience is going to be a little better at some of these things, making decisions on living expenses, rehabilitation, whether modification might be needed in the future, and how long it should last. It's something that just with time and age and experience, this area of spousal support gets a little easier to understand. I mean, for example, if you're a high school student today, you aren't thinking about your retirement. As such, how much money you're going to need in the future is really not on your mind. So it's a non-question. It's something you're not thinking about at a younger age. As you get older and you get experiences, as I call them, the wilderness experiences, where money is just not working in favor of you. You don't have resources like you did when you were in high school and had your parents and other family to rely on. The older you get, the less likely it is that you're going to have that type of resource. The parents die, or the parents may not have anything. Siblings, brothers, sisters, bringing this up because, when you're younger, you have some resources that people simply may not have when they come into your office. Their only resource may be the other spouse, and they may not be working, so it even drills down even further to the other spouse. All right? And, but the important thing also to this conversation is the Florida alimony spousal support laws have evolved a great deal since 2011. And what we generally used for legal analysis often was case law. And so in 2011, the Florida legislature started making extensive revisions to the Florida alimony statute, and their intention was to codify case law. And as you know, legislatures do this. The case law may, it continues to reach if courts continue in the appellate level, continue to reach the same decisions over and over on the same types of appeals, well, it's time to codify it or codify it, whichever terminology or whichever pronunciation you like. But that's something that the legislature will do to take the problems out of to put the problems into a formal approach in the legislation, and have that be the guidance of people. In 2023, another big substantive change took place in the Florida legislature, and the legislature abolished permanent alimony. And as far as alimony is concerned, it centers around the legal duty to support your spouse and children. It brings in a public dimension, because if there is a person in the couple, if the couple has one person who has the ability to support, and the other one does not, the courts are not likely, even with a premarital agreement, to leave a person destitute, broke, busted, and disgusted. They don't want that. Then they become, there becomes a need for support from the state. And we talked about premarital agreements and that sort of thing in an earlier chapter, and recall that you can write these types of things down in the contract, but because of this dimension, the public dimension, it can be overcome and defeated in a contract. The contract will not always defeat the need for alimony. The duty gets triggered by this other spouse's inability to support themselves. Now again, in the adulting world, what causes that inability could be employment, could be health, could be age, could be health, both mental and physical. Many things come into life that make it hard to get a job, and make it hard to work. And so I think, don't call it getting a job, asking the question, can this person work? Can this person earn the income needed? If they do, what does that look like? So again, it's pretty adult stuff. The intricate multifactorial analysis that's used in the determination of spousal support, we use the courts use this multifactorial analysis to determine whether it's equitable. So the court's still looking, are we going to saddle a spouse with the obligation to support the other after the marriage is over? And so and it is the goal, the courts do want spouses to no longer have a relationship, including a financial relationship. It's one thing when they have children and they have that, but a financial relationship in the form of spousal support, courts do want to avoid that. But again, keeping in mind that if one is able to pay and the trigger has happened where there's one spouse's inability to support themselves, and that public dimension comes into play in the court's minds, and they start to look to see how this can be solved. All right, so there are three classifications of alimony. One of them is lump sum. It may be a sum in a single payment or in installments. It does not terminate on death, and the useful thing to remember is that it's illegal fiction in some cases. Lump sum alimony may not be true alimony, and may more likely be intended for post-dissolution. And so you have to make the determination: is this alimony for a mechanism for distribution of marital property? We haven't gotten to the distribution of marital property yet. That's coming up in the next chapter. Understand that because we have a statute or statutes that help the courts make decisions on distribution of marital property, they would follow that in that vein. And also, they would not make a decision on alimony, meaning that after the divorce is finalized, they would not be making a decision on alimony until after property distribution comes about. Again, sometimes lump sum is dealing with a property distribution principle, and it's care needs to be taken. Lawyers know how to do that, how to be careful about doing that. But first of all, it's not modifiable type of alimony. So what you get is what you get, and that's why careful thought needs to go into it. The second district, and I bring up the second district specifically, the article which is referenced at the very last slide on this deck that I used to prepare this lecture, point out other districts, but I included the second district in this one because my students are in Manatee, Sarasota, and DeSoto counties in Florida, and those three counties happen to fall into the second district. And as such, if there's a situation where you're using case law to solve a problem and to make a prediction as to how a court might hold, we would look for the mandatory authority of cases that are out of the second district, or the mandatory authority of the Florida Supreme Court, which sits above the second district. So that's a whole different story, but it's important to recognize that what I'm citing to what I'm telling you right now, it says the second district has consistently held that trial courts should not intermingle asset distribution and alimony issues, i.e. lump sum alimony as a property distribution, because the equitable distribution statute deals with property and debt distribution. Anyway, that's important to know if you're in the second district in Florida. Alternative route we have in Florida is the gap alimony, applying that to a situation where marriage is under 7 years, 1 to 7 years of length. Another classification is rehabilitative alimony. And this is a place, again, where, this is where adult things have happened, and not always. I mean, I'm just saying that the more experience you have observing others and seeing what goes on in other people's lives and yourself makes a difference in your knowledge. So the rehabilitative alimony is one that provides a divorcing spouse with the opportunity to gain increased capability of self-support. In other words, is there education needed? Is there any type of rehabilitation? Let's just say rehabilitation for an injury, rehabilitation for alcohol and drug dependence, that sort of thing. Rehabilitation, such as those examples, are those that would, if effective, be of the type that increases the person's capability of self-support. Courts have differing views about rehabilitative alimony. One is to provide an opportunity for the former spouse to establish the capacity, as I just noted, for self-support and commensurate with the standard of living established during the course of the marriage. Also, to permit the spouse to regain the ability for self-support similar to that which previously existed or would have existed except for the marriage of the parties, and to provide funds to the requesting spouse to establish the capacity for self-support, either through the redevelopment of previous skills or the provision of training necessary to develop potential supportive skills. Again, these can be in different forms, like I said, education, rehabilitation for alcohol or drug dependency, or possibly medical rehabilitation. All right, with the rehabilitative alimony, a plan needs to be made. Now, sometimes in family law, they might use an occupational therapist. That's somebody that understands the way life works. They know things like sitting, standing. So when they say occupational therapy, don't assume that's talking about work therapy. But how you occupy and live your life, the things you need to be capable of doing to, if you think about a rehabilitative plan for a person who's been in a major accident and they need to bring themselves back to that capacity to earn. The rehabilitation plan needs to include, what that looks like. It has to be detailed. How many months? So this is going to take doctors' information, medical records, and probably in some cases a expert witness like a occupational therapist to help define what that would look like. If the party cannot become self-sufficient, a rehabilitative alimony is inappropriate, and thus that's why the plan is helpful to the court and to the client if your client is seeking alimony. If there is no prognosis of becoming well again, I'll choose something horrible to think about, but dementia or Alzheimer's, if that's not going to happen, a rehabilitative alimony is not appropriate under that circumstance. So the duration of the marriage plays a different role in evaluating rehabilitative alimony claim. The 3-tier durational classification of marriages, which we saw it early, and there's probably coming up on the deck again soon, of short-term, moderate-term, long-term. We used that, which was used in permanent alimony analysis. So the duration of the marriage plays a different role in evaluating the rehabilitative alimony, and that durational classifications of short-term, moderate-term, and long-term that were once used for permanent alimony analysis is not used. Sorry, I said that wrong. All right, another classification of alimony is bridge the gap alimony, and that's a form of temporary support. It's used when the criteria for rehabilitative alimony are absent, and it's most appropriately awarded when the receiving spouse is already employed and requires no rehab other than a brief time to make the transition to single life. It's based on expenses identified with specificity. The duration of this form of alimony is limited by case law and now has been expressly limited to 2 years in the 2010 statute, as I pointed out at the beginning of this lecture. the case law was codified by the legislature. What else do I want to say about this? The duration of this form of alimony limited. And so with durational alimony, while there's no specific detailed rehabilitative plan, like the rehabilitative plan, there needs to be some specifics outlined for the court. The financial affidavits and mandatory discovery also aid the court and aid us in informing the court of what this might look like as as a form of temporary alimony. Another classification of alimony is durational alimony. And durational alimony serves as a primary option for longer-term support after the elimination of permanent alimony was made in July of 2023. It's awarded for a set period. It can be modified or terminated, and the reasons for modification or termination are substantial change in circumstances. And typically it cannot exceed 50% of the marriage's length, but courts can award more in exceptional cases. A little more on durational alimony. Its purpose is to provide financial support for a specific period, especially in long-term marriages, to allow a spouse time to adjust financially. Its duration is typically capped at a percentage of the marriage's length, like I said earlier, usually no more than 50% unless the situation is extreme. So a short-term marriage is one under this area of durational alimony that's less than 10 years. A moderate term marriage is 10 to 20 years, and a long-term marriage is 20 plus years. Next, it terminates upon the death of either party or the remarriage of the recipient, and indeed it can be modified, as pointed out earlier, upon the showing of substantial change in circumstances. Permanent periodic alimony, as I pointed out, it was formerly the norm. This was an old slide, so I kept it as is, something I used years ago, 11 years ago, quite a while ago, in one of my lectures. But there is no such thing as permanent periodic alimony in Florida, other than awards that are already made. It didn't squash all the awards that were already out there. All right. So these are the areas that we're looking to, just 6 types of alimony claims. Like, what would you expect when a client comes in the door and you're wondering about their interest in alimony, their need for alimony? So there can be alimony pendente lite, which is during the divorce proceedings, and again, that's covered as maintenance, and alimony for support during marriage without a dissolution action, such as a separation, legal separation, where they remain married but they're separated physically, and that's a separate maintenance. Then we have alimony after dissolution to ease the transition to single life, and that's the bridge the gap alimony. Alimony after dissolution allows a spouse to prepare for self-sufficiency, and that's called rehabilitative alimony. And generic temporary post-judgment alimony, which is durational, and alimony after dissolution in a fixed liquidated amount, which is lump sum. When the court is awarding alimony, when you as a legal professional are talking to clients for information, the criteria for awarding the alimony is where you start looking for the information you need. What are their resources? What are their financial resources? How long will self-sufficiency take to reach? What's the length of the marriage? And what's their age and physical and mental condition of the payee? The responsibility to care for others. Are there children? The courts will look to that. Again, this is why they look to alimony like last. After property settlement distribution, I should say, after property distribution is determined and after child support is determined, then the alimony question comes into play for permanent. I don't mean permanent, but alimony is in post-dissolution. So the standard of living during the marriage also plays a key role in alimony awards. So our statute for Florida is gender neutral, and it's Florida statute, chapter 61, .001 sub A, and it specifically states that its purpose is to preserve the integrity of marriage and to safeguard meaningful family relationships, to promote the amicable settlement of disputes that arise between parties to a marriage, and to mitigate the potential harm to the spouses and their children caused by the process of the legal dissolution of marriage. In Florida, there's a two-step approach to determining alimony. The first step, if you look to Florida Statute, Chapter 61.08, that says where the court makes specific factual determination as to whether either party has an actual need for alimony or maintenance, and whether either party has the ability to pay. So it all comes down to need and ability to pay, always, always, always. If the court finds there is a need and an ability to pay, the court determines the proper type and amount of alimony or maintenance. Of course, it's the legal professional, the lawyer's job to convince the court what type is best. They take in all relevant factors. That last slide, a couple slides ago, with the blue boxes, blue rectangles. That's what I'm talking about here. And it's not limited to those just set out in the statutes. So there are 10 relevant factors, if I'm not mistaken, and all of those go into play. But again, everybody's different. Everybody's life is different. It isn't that simple to simply use a formula like this and it works every time. So the court may consider the adultery of either spouse and any resulting economic impact in determining the amount of alimony, if any, is to be awarded. I'll get back to this point in another slide separately. Now, alimony awards are discretionary type of awards, according to Florida Statute, Chapter 61.08, subsection 2. So the court has discretion, and it has to base its decision on whether one party has a need and whether the other one has an ability to pay. The case of Canacaris versus Canacaris is a famous 1980 Florida Supreme Court case, and it does a lot of governing in areas of family law, so you should read that and know that. It can be challenged. Alimony awards can be challenged for abuse of discretion. So that's just because the courts do have wide discretion. If it's abused, if that discretion is abused, it can be challenged on appeal. Alimony awards can also be waived by the mutual consent of both parties. And when there is an alimony award, the order must make written findings regarding the 10 factors set out in the statutes. These are 9 factors. There's a 10th, but I think it was such a long slide, I tried to narrow it out, make it shorter, and somehow deleted more than I wanted. But sorry about that. But it's all covered in Florida Statute, Chapter 61.08, subsection 3. And again, I'm going to be repetitive if I read this off. The duration of the marriage, the standard of living, the anticipated needs and necessities, age, physical, mental, emotional condition, resources and income, earning capacities, education, vocation, blah, blah, blah. Contribution of each party to the marriage, including services in homemaking, child care, education, and career building of the other party, and the responsibilities that each party will have in regard to the children, and other necessary factors to bring for equity and justice between the parties. So, looking at the threshold test. The threshold test for alimony is the need and ability test. Need and ability to pay is the threshold requirement for any form of alimony. So, where parties have substantially similar financial circumstances, the test just ends. There's not alimony permitted. They walk in there with the same deck of cards. It's the same for each one. There's not an alimony award coming. But where there is disparate income, like one with substantial income and the other one's unemployed, alimony is typically required. The party claiming alimony must meet the need, which is the inability to meet their recurring financial needs with their own financial resources. and that need also refers to the standard of living enjoyed during the marriage. The next step after need is the ability to pay and meet those needs. After the court looks at the threshold requirement, it looks to the party. This next step is where the extent of their ability to meet their needs. So this is the person claiming alimony. They'll look to the ability through current employment income and income from assets. It's also, as far as ability, the court may impute income. And that's because potential income may be less right now on paper. Could be something manipulative that the claimant has done. Quit a job for no reason, got out of a lucrative job of employment without a reason, and that happens to gain some litigation posture. Now we look to the extent of the need. Now, the extent of the need, even though we look to the past, how the standard of living, the extent of the need isn't based on the standard of living. It's based on the future need, not past needs. And so reasonable expenditures prior to time divorce was anticipated is a historical type of measurement. And so the extent to which those expenditures could be maintained with two parties in separate households, which is future needs. And after determining those future needs for the party claiming, they'll subtract the party's recurring income. That would be the income the party could provide for themselves. With that, they would include any potential income that the party is voluntarily foregoing, which goes back to that imputed income topic that I mentioned earlier. And this method is not a mathematical operation. It is very conceptual in terms of approximating a person's future needs. And again, goes back to some fairly high volume, I'm going to call it, not level, high volume of information to take into account, and just life in general, what it's like for that person, and what their resources are and aren't. So it's the first level of expenditure a party would require to maintain a reasonable semblance of lifestyle enjoyed during the marriage, and discounted by the higher cost of living separately, future needs. The next step after that is the ability to pay, and the court has already passed the threshold test. However, if ability to fund requires a look at the circumstance, will also require a look at the circumstances of the payer. And I should note that I have been spelling payer, P-A-Y-E-R, instead of P-A-Y-O-R for a reason. It tends to confuse some of my students, so this just looks like what it is, payer, as opposed to payor. So it's not uncommon for parties to deliberately reduce their income, as I pointed out earlier, to posture themselves for litigation. And so it is subject to imputation of income on both sides. Determining the amount, once the need and ability to pay standard is satisfied, the award should be either the recipient's need or the limit of the payer's ability to pay, whichever is less. The 2011 amendments to the Florida statutes prohibited alimony awards exceeding the payer's net income. In modification proceedings, there's a conflict among the districts about this rule. So while the amendments are dealing with awards, modification of awards, I suppose that's one of the next areas the legislature may choose to codify something. I don't know. I don't have any direct information about that, but it's possible. So the goal of alimony, however, is not to equalize anyone. It's not property distribution, but this can happen. And even property distribution doesn't necessarily it does have the goal of equalization. And that can happen. But in alimony, it's not the goal, but it, as I point out, can happen. Now, there is a semi-mathematical approach that really just resembles the other approach, but it was interesting to take a look at this one. The amount of alimony, again, is in the discretion of the court. And need and ability to pay test is what complicates discretion of court standards, okay? Deviation, that means more or less than the amount that seems to come up at mathematically. Deviation from the alimony level, it's difficult to accomplish because of the need and ability to pay test, the one we just went through, even when there is this discretion. And appeals that reverse trial court judgments that don't provide for the level of need when the other party has ability to pay, and that exceeds the demonstrated need or the other party's ability to pay. So you see where trouble starts in the court process of determining an alimony, and there have been reversals for those particular reasons, for not staying within the limits of what we already talked about. Plus, there's this alternate semi-mathematical approach that's also used in calculating alimony. So this formula looks like this. Assuming both parties' incomes and expenses are precisely known, all right, you can calculate the need and ability with this formula. Need would be the reasonable expenses minus the combination of actual income and imputed income. Ability would be a combination of actual income plus imputed income minus reasonable expenses. So alimony would be determined by the minimum of need and ability. It resembles the other test we used earlier, but this is one where we can use a mathematical framework, and there are this is when we have precise information about need and ability, about their income and expenses. So in plain English, alimony is the lower of the need figure for the ability to pay figure. The lower of the need figure or the ability to pay figure. It's true because three primary principles from case law include alimony must fully fund the claiming party's need if ability to pay is shown. Alimony may not exceed the payer's ability to pay, and alimony may not exceed the claiming party's need. The only excuse for not awarding alimony that fully funds the need is if the other party does not have sufficient resources to pay it. In that case, the amount that can be paid must be paid. So looking at the balance of income and resources in Florida, final awards of alimony are always made after the division of property. I just explained that earlier. So the resources of each spouse can be examined when that is weighted, when we know how much property resources they have. Parental responsibility and support will also have an effect because that will change the amount of income available, and it'll change the ability of a spouse to seek full-time employment in some cases. So this one I promised I'd come back to, the conduct of the parties in determining alimony. So the court may consider the adultery of either spouse and any resulting economic impact in determining the amount of alimony, if any, to be awarded. That's from Florida Statute, Chapter 61.08, subsection 1A. And then there's the case from 1986. It's Noah versus Noah. In this case, it lists there were dissipation of assets and adultery that were concerned. So dissipation of assets is where a person is maybe a spendthrift, spending money on the paramour, which is the affair, the person they're having an affair with. What I'm really wanting to drive in is that and is really important in the statute. It's not just we can consider the adultery of either spouse. If there's no or there, It says, and any resulting impact. So there must be evidence that the adultery translated to payee spouse's greater financial need, or that the adultery depleted family resources. All right, waiver and nominal awards. Many couples have comparable incomes and just choose to forego alimony. You wouldn't get it anyway. A waiver ends the question for final awards, and there can be no modification. And a nominal award of $1, maybe, just an example, that reserves the jurisdiction of the court in the case there's something unanticipated that represents a significant change in the payer's circumstances. And this prevents any party from benefiting from tactical, self-inflicted economic wounds, that we see this commonly in divorce on both sides, pay or payee. So that if there's a substantial change in circumstances since the divorce, then that can be looked to for modification. That's what that $1 and reservation of jurisdiction allows for. Payment of alimony, we can have more than one type of alimony awarded, and the circumstances of the case are how we limit what is reasonable. Alimony orders may include periodic increases, such as an escalation clause, a cost of living increase, and depending on the type of alimony, may not be modifiable. And other protections are also available. Payer's obligation to maintain life insurance policy or a bond as a way of securing the award, or securing the award with the suitable type of assets, according to Florida Statute, Chapter 61.08, subsection 4. Healthcare coverage may be included, and modification of alimony. So here we move to the modification standards. There has to be a substantial change of circumstances of a continuing nature involving the payer's ability to pay and or the payee's financial need. The ex-spouse must not be using the change in circumstances as a pretext for avoiding the original or alimony amount. Modification of the alimony. More on this. Some types of alimony are non-modifiable. Durational alimony, for example, is non-modifiable. Parties can also agree that alimony is not modifiable, but the court does not arbitrarily make non-modifiable an award that would, under law, be modifiable. So it is what it is. The court shouldn't make awards that are different than what is. The test is substantial change in circumstances, which might come in the form of significant change in income, retirement, remarriage or cohabitation of the award recipient, the major health issues, substantial inheritance or a windfall, completion of a rehabilitative plan. Court-ordered alimony must be modified in a court action. We don't make these decisions unilaterally. An official motion to modify would be taken care of through the courts. The modifiable nature of some types of alimony naturally means that the court retains its jurisdiction over it. And that power ends when the period of payments has been reached. So when the final payment is made, the court no longer has jurisdiction. Remarriage of the payee or payor. If the payee remarries, alimony payments cease unless the separation agreement or court order provides that the payments continue after payee's remarriage. Payer gets remarried, alimony payments to the first spouse must continue unless a separation agreement or a court provides that the payments cease or are reduced. So the effect of a supportive relationship, so this is a situation where someone has not remarried, but there is a supportive relationship, and the payer of alimony may seek a reduction or termination of the alimony amount if the recipient is involved in a supportive relationship. The payer has the burden of proof to show that the recipient resides with another person, in a relationship that is characterized as supportive. So many factors are considered by the Florida courts. Florida Statute, Chapter 61.14, subsection 1b, is where you can find that information. Possible reasons they held themselves. Okay, and so if you think about common law marriage, which we abolished in Florida, effective 1964, but you got to define the cohabitation, and it looks somewhat like common law. Held themselves out to be married, length of time together, are they pooling their assets, how much support is the other one providing to the other, the supportive friend, supportive relationship person, has one performed valuable services for the other or the other's company or employer? Are they working on together on something of value, building a business, building a house? Joint contributions to real or personal property, express agreement to share or support property, and providing support to the other's children. Death has an effect on lots of things, including alimony. It is not extinguished death does not extinguish a lump sum alimony award, because there's a vested right in property with lump sum. And incomplete property division transfers, they will survive as a debt against the estate. And life insurance can provide ongoing support. And otherwise, alimony is terminated by the death of the payer, and there's no further charge against his or her estate. Bankruptcy effect on the alimony obligation, the domestic support obligations, DSOs, such as alimony debts of the payer, they're not extinguished. That term in bankruptcy is called discharged by the bankruptcy. Basically, after the bankruptcy, the payer, who was the debtor in bankruptcy, who also has this alimony obligation, to the spouse, the payee, continues to owe all arrears, unpaid or delinquent alimony debts. They must continue to pay all future alimony debts. Income tax treatment. After 2018, alimony payments are not taxable to the payee, so the person receiving alimony does not have to report that as income, but they're not deductible by the payer either. Enforcing an alimony obligation, there are a few ways. We've got execution through the court system, garnishment. I don't mean execution as in executing against property, if it's possible. Garnishment of wages, a fine is possible. There's both civil and criminal contempt. And we have the 4D agency assistance, which is a federally funded state agency that helps to assist people in obligations that they, for their well-being. Child support is a big one. And I'm assuming alimony too. So criminal contempt proceedings, they are rare in family law because they're difficult to successfully maintain and rarely result in payment anyway. Civil contempt proceedings under Family Law Rule of Procedure 12.615 are the most common because their goal is to coerce the payment that has already been ordered. An obligor, payer who fails to pay support installment when due, could be held in contempt of court if they failed to establish that their failure was involuntary. So, lastly, here's my slide with the references. These are both very good references. This Florida Bar is from Westlaw, so I don't know if you'd have to get with the library if you're out there in the general public and want to read that. It's an excellent tool for understanding Florida alimony law. And then William Statsky's family law text. So thank you very much.